It's 5 o'clock on Wednesday, March the 17th. The House Criminal Justice Subcommittee is back in session. We're going to dispense with the roll. Without objection, we're going to go back out of session to hear more testimony. Out of session. Before we begin, before we call up our next witness, I just want to let the committee and those that are here know how we will proceed for the remainder of the evening. I have several that are listed here willing to testify. We're going to call you up each one at a time and allow you your 4 minutes to speak. Afterwards, once you have completed speaking, the members of the committee will have the opportunity to call you back up for questioning. So if you will, members, make notes if you have questions or comments that you would like to make to these guests that we have today. That way we can call them back up to engage in that conversation. All right. Well, we have on our list Terry Bell. If you would, please, you can come to the table or you can go to that podium right there. Introduce yourself, please, for the record, organization you're with, and you will have 4 minutes to make your statement.
Director of Madison County Community Corrections. Obviously, we have Madison County. We also have Chester and Henderson counties. We cover the 26th Judicial District. I've got 14 employees. We cover and supervise 700 offenders, and our costs per day are $2.80. Our 36-month recidivism rate is 2%. We have had audits year after year, and our last one had no findings. And of course, the comptroller audits our county as well, and no findings there. We enjoy the strong support of our circuit judges. Even while waiting here, I've talked to all three of them today, concerned about what's going on. My attorney general has called today, wanting to know how this is going. Public defender, our sheriffs, our clerks. I've talked to clerks today while we're here. County mayors and treatment providers. We have strong relationships with all of these people and so many more. And that's because we're from the community and we maintain close ties and we try to serve their very needs that they ask for us to take care of. Among those needs is something that's really important to me because I used to be a recovery court coordinator, drug court back then, and certified a drug court with Judge Allen. And we have 30 offenders in both the veteran court with Judge Atkins and a recovery court with Judge Atkins and with Judge Allen. We take great pride in trying to help those offenders work through that program. It's very intense. And if you may not be fully aware how a recovery court works, but the supervision piece, the drug screening, is like 40% of the work. The treatment is the other 40%. So we cover, this, along with the treatment provider, an enormous amount of the work that goes into that. We work to reduce family violence by responding and putting together a 26-week domestic violence course that uses the Duluth model. We offer anger management courses. We worry about safe streets and the issues with DUIs, and we have a DUI school that's offered. We seek genuine and real change in the offenders that we're given. And by doing that, when we go through these strong R's assessments that you've heard so much about probably, we don't just assess it, but we make sure that they get what they need. Sometimes internally with it, we provide substance abuse courses and cognitive behavior courses there internally. But we also refer them to all these treatment providers throughout the community that we have such strong contacts with. It's just an important part of that. We also reach out to various organizations and team with them to make sure that transportation issues, housing issues, even meals, whatever they need. Not too long ago, I carried one to the health department to help him get his birth certificate and then hauled him out to the highway or to the Department of Safety to get his ID because he couldn't get a job and he was going to be homeless. We care about these people and we care deeply, and we work to try to help them change their life and reach that rung and climb up it. We work with our community service programs. We go out into the communities, taking care of blighted areas. We work on a regular basis with Pinson Mound State Park. It's a little park that doesn't have a lot of help, and we go down there every month picking up their trash, cleaning up their trails, taking care of those situations. The Carl Perkins Center for Prevention of Child Abuse, that's our CAC. Every time they have an event, we're there carrying the load. We're there for our people, and that's why you're hearing from those people. Because we're real, and we make a genuine contact with the community. And we want to continue to do that.
Thank you, Mr. Bell, for your testimony. You're 4 minutes up, but thank you. And members, if you had questions for him, please make sure you made a note. You can call him back up here shortly. Next on our list is a Michael Walton. If you would, please identify yourself for the record, organization you represent, and you'll have 4 minutes for your comments.
Thank you, Mr. Chairman. Members, my name is Michael Walton. I'm the program manager for West State Corrections Network. We cover Obion, Weakley, Dyer, and Lake County in the 27th and 29th judicial districts. We are a private company. Our company's been in business since 1993, and this June I will have 18 years with this company. I had the privilege of serving on Commissioner Parker's Probation and Parole Subcommittee as part of Governor Lee's Criminal Justice Task Force. And to the best of my knowledge, this subcommittee that I was part of did not make the recommendation to abolish community corrections. And, I'm all for the criminal justice reform, but in my opinion, to abolish a program that costs approximately $4.60 a day for a community corrections offender to be under supervision, for the 18 is, in my opinion, is not, criminal justice reform. Community corrections by contract is allowed to have a 40-to-1 offender-officer ratio. This allows us to have more of a hands-on approach to help our offenders in areas where their assessment says that they need help in. I believe currently state probation has an 85-to-90 offender-officer ratio. With that type of ratio, no wonder why most intakes for community corrections come from offenders that have been revoked from state probation and then placed under community corrections. Community corrections is more of a house arrest type program. So if the Department of Correction Administration would like to lower the requirements of supervision for community corrections, we could support that change. In 2020, Community Corrections Association, which I'm president of, supported Governor Lee's criminal justice reform initiatives, which included a comprehensive data collection program. We're not sure why this data collection program was abandoned, but would love the opportunity to work with the department. Thank you.
Thank you very much. Next on our list is a Christy Holt. If you would, please introduce yourself, and you'll have 4 minutes.
Hi, Chairman Doggett and committee members. I really appreciate this opportunity. My name is Christy Holt. I am the director of Montgomery and Robertson County Community Corrections Program here in the state of Tennessee. And I come today in front of you with 27 years of experience in the criminal justice system. Within those years of experience, I have served in law enforcement. I have served in criminal justice education. I have been a probation officer, community corrections officer, and now, as I stated, I am now a community corrections director. So hopefully with that being said, you can see my passion for what we do and the fact that I've spent so many years dealing with a population that most people would rather not deal with. So it does mean a lot to me. So with that going forward, I am asking today that you vote against House Bill 784 as it states it wants to abolish community corrections. Community corrections is such a special entity. It's unlike anything else in the criminal justice system. And I know that because I've been there and done that. Community corrections provides services that no other entity in the whole system, from the beginning point to the ending point, nobody else offers what we offer. Nobody else is set up to offer what we offer. They're not equipped, and quite frankly, I don't think they would have the same care and concern that we have developed over the many years that we've been in place. Being in place as long as we have learned how important we are to the offenders. And we have learned how if we don't provide it, it doesn't get done. And it needs to be done in a caring fashion. So today, my part of the testimony, I want to give you a little insight, rather brief because of the time constraints that we have, but let me give you an idea of what we offer through our program to these offenders through our intensive supervision. We see these offenders daily at times. They call our office every time they have a crisis. It's not once a month, once every 3 months, once every 6 months. We know these families, these spouses, these children, when they have a death in the family. So just to give you a list, if you'll indulge me for a moment, of what we do discuss and help the offenders with, it might be employment resources, life skills, transportation resources, child care, education, housing, medical needs, food, clothing needs, basic hygiene, any type of treatment that they are seeking, whether it be substance abuse treatment, mental health treatment, basic counseling. It goes across the gamut. Veteran services. I know in our county we are blessed. We have a veterans court that is very strong and thriving. We have a teamwork system in place with those. We are closely related to Fort Campbell. We have veterans. We send them through veteran services on top of our services to make sure that they get the understanding that they need. And anger management, any type of need that they bring to the table to us, we address. If we don't have it on site, we find it. And again, I can speak for my own counties. We are blessed. We have a very supportive administration. We have very supportive community services, to include faith-based. Anytime we pick up that phone and let them know we have an offender in need, they jump to help because we have established that rapport. You're not going to find that anywhere else in the system. And I really think that's where Governor Lee is wanting to get. We are there. We just need you to know that. We have what is needed. We just ask that you give us a continued opportunity to provide it. Thank you.
Thank you, madam. Thank you for your testimony. Next on our list, Wes Morgan.
He's not here. I do not believe he's here. That was a client, and he's got some flight issues, and I don't believe he's going to be here.
Okay, okay.
May actually not be able to get in the building since it's after hours. I don't know if the front's closed.
Maybe 5 o'clock. Do we want to take a brief recess or? Okay. Okay. If you find out he's there, we'll make sure that we get him in. We'll go next on our list, Miss Callan Schmid. If you will, introduce yourself for the record, and who you're with, and then you will have 4 minutes for your testimony.
Hello, Chairman, and thank you, members of the committee, for hearing my testimony today. My name is Callan Schmid, and I'm a legislative liaison for Governor Lee, here to discuss 784, which we refer to as our Alternatives to Incarceration bill. As you all know, we spent the past several years in pursuit of the governor's and your vision for a more transparent, accountable, and effective justice system. The work of the Governor's Criminal Justice Investment Task Force and of our team and many stakeholders over the past 2 years has resulted in the proposals before you today. I would be remiss if I didn't take the time to thank all involved for their efforts that have led us to today. The bill addresses alternatives to incarceration, including drug treatment, alternative courts, and probation practices, none of which are new here in Tennessee, but all of which have opportunities for improvement. While our criminal justice data isn't perfect, and in fact something that we are actively improving, the data we have paints a clear picture that individuals with substance use, mental or behavioral health issues are entering the system at historically high rates. Our criminal justice system isn't designed to be, and arguably shouldn't be, a specialized healthcare treatment provider, a parent, a fairy godmother, or to those who walk through its front doors. We can all agree, however, that when an individual becomes justice involved, it is imperative that we do all we can to ensure that they do not reoffend and have access to the resources they need to rectify the behavior that led to their criminal act. This bill seeks to do just that. In multiple parts of the bill, we work to ensure that judicial discretion is used appropriately in line with data-driven best practices to shepherd an individual towards an optimal outcome. We address eligibility to recovery courts, conservatively expanding who has access to these highly effective programs. We ask judges to consider the needs of the offender before them, as supported by clinical assessments when making sentencing decisions. We recognize that even short stays in jail are proven by research to sometimes do more harm than good, and have worked carefully with judges to make sure that when public safety considerations allow, we are able to safely release more defendants in their communities pending their sentencing. We have taken steps to elevate opportunities to use day reporting centers as alternatives to incarceration, as we continue to scale their presence across the state in light of their excellent recidivism statistics. We are applying evidence-driven best practices to probation supervision, including limiting the amount of time for which a defendant can be sentenced to a period of probation. Research has clearly shown that longer probation terms are not effective at changing an individual's behavior, nor do they have a deterrent effect. We address responses to technical violations to standardized practices across jurisdictions, a change made in response to an increasing concern about inconsistent responses to like behaviors. We also make clear that the focus of probation supervision should be on driving the defendant towards success by directing them towards the evidence-based program that fits their unique needs. Probation is not and should not be one size fits all. Lastly, we know that a large area of confusion and concern centered around the proposed redesign of the Community Corrections Grant Program. I'd like to attempt to clear that up. The grant program was originally implemented in 1985 in response to severe overcrowding concerns in our prisons and the federal takeover of TDOC. These grants were to create additional supervision capacity for probation that TDOC could not have at that time. Thankfully, those problems have long since been resolved, but the Community Corrections Program has not since changed. It may be a hard truth, but the recidivism data clearly supports a need for higher accountability and improved stewardship of taxpayer dollars. Since this legislation has been filed, and even as early as this morning, we've had a number of conversations and received a great deal of feedback from members of the General Assembly and stakeholders. We look forward to working with the community corrections agencies, with you all, to come up with a solution that will allow us to increase accountability for outcomes for those on community corrections and make fiscally sound investments into our programs. Every Tennessean and every community deserves our equal commitment to high-quality public safety outcomes. Thank you.
Thank you very much. All right, next on our list is an April Clark. And I'm sorry, I apologize. I overlooked you there, and when I grabbed you got you up here just a minute ago, but I'm sorry.
Hey,
So,
that's okay. Thank you all. Thank you for hearing from us today, and actually the many emails and phone calls that you have received throughout the last 45 days. So I appreciate you taking the time to learn and listen as to what we do. I am April Clark, and I have 29 years' experience serving the Mid-Cumberland Human Resource Agency Community Corrections Program. That is the 12-county area that surrounds Davidson County. The assumption that community corrections has been unchanged since 1985 is just simply not true. At Mid-Cumberland, we've continued to evolve. We are completely paperless program supervision. We're the first in case management system in the state of Tennessee to become paperless. That's something that Probation and Pro has still not done. We have developed and implemented new programming. We have 30-year relationships with treatment providers, Department of Mental Health, drug courts, veterans courts, recovery courts, all of which assist offenders in needs. Those are relationships that we can't rebuild if we start over from the ground up. Those are folks that if offender needs treatment, I can call them at 8 o'clock at night and say, hey, I have this offender, I need you to get them into treatment. Can you get them in tonight? And yes, okay, so have them come to this designated place and we'll get them in. We talked about data collection. I agree. The Criminal Justice Task Force said that we need to evaluate the effectiveness of community corrections. We were thrilled and excited with that. We felt like that if we had the proper attention of the administration, we could show our success. We would line directly up with the administration's desire to provide strong community supervision with offender services and less offenders in prison. True data collection is key, and the department's TOMAS system is simply not the system to provide proper data, especially when it pertains to recidivism rates and the successful rates of community corrections. Without us, people will go to prison. That's it. We are alternative sentencing. We're the step between probation and prison. We have cases that the judges and the DAs do not want on probation, therefore they give them to us. And if we don't supervise them for $4.58 a day, my fear is in the future we're going to just continue to drive prison beds up. Our officers see our offenders. We see people a minimum of 5 to 10 times a month. That gives us plenty of opportunity to provide programming, continuously drug testing them. We go to their homes. Our officers know their clients. They literally are in the side of the homes, knowing who their parents, spouses, children. I've had officers, if their children are struggling in school, we connect those dots. Whatever the offender needs in order to be successful, we want to do. We create a pathway for success by getting them the treatment, whether it's inpatient, outpatient, whatever that is. We also do a validated risk needs assessment, which addresses everything from education, finance, children to employment. We connect offenders with help centers in their communities, and I have about 8 of my counties are very rural. Those communities do not have help centers. So my officers will go to other help centers. We've partnered with those programs to bring stuff back to our offenders from those help centers. You won't find that in larger caseload supervision. We help moms turn back to being moms and dads turn back to being dads, paying taxes and enjoying a life that crime and addiction took from them. To me, that's the most important part. We all know that children of addicted parents or overdosed felony offenders or just offenders in general, those are the true folks who are the victims. Those are the ones that suffer. With the overdose continuing to increase, it's my fear that less supervision is going to cause more overdoses. Lastly, I want to ask you to save our program. Without saving us, we would have 250 officers and employees unemployed by transferring 7,700 offenders to probation. 6,000 of those actively report to the 18 programs in this room. You're going to take those 6,000 offenders, put them to reporting less often, getting less supervision, and that scares me with no new staff. So I'll be glad to take questions at the time. Thank you.
Thank you so much. Were we able to locate Wes Morgan?
Yes,
Okay. I don't have anyone else on my list, so we'll take a brief. Here he comes. All right. Mr. Morgan? Yes, sir. You still want to testify? Absolutely. Well, come on up. Well, yes, sir. Hey, yeah. Well, you can sit or you can stand. It's your choice. Well, you choose. It's up to you. That's fine. You stand there, and if you will, there's a little button there. It should turn red there, and you can introduce yourself, organization you're with, and you will have 4 minutes to testify.
Yes, sir. I'm Wes Morgan, and I represent a plethora of things, so I won't get into that. But I am here to say how much respect I have for community corrections. I come into community corrections. Actually, this March will be 14 years clean from cocaine and crack, and a long list of criminal records. And community corrections saved my life because they took the number off my back, basically. And they said to me that you can change, and I did change. And I'm, again, celebrating, if I could get a hand clap, 13 years this March. Feel like I'm in church or something. But, you know, I just got off the road. I'm getting back. I'm catching a flight tonight. I made sure that I got here because I want to represent the credibility of this organization and what they did in my life. They saved my life. I mean, I thought I pretty much, you know, I would be just a dope head for the rest of my life, but they applied so much accountability in my life. And I don't know if Mr. Brooks Dillinger is in here or if Jennifer's in here, but these people kept me accountable, and that's what saved my life. I thought that my kid would probably find me in a hotel room somewhere, overdosed. But because of community corrections, they made me be accountable. And that is what is the integrity of community corrections, is because they hold people accountable. And that's what saved my life. Had I not had to come in there and do drug testing every week, I probably wouldn't be here today. But they help me by keeping me accountable. And that, to me, is the backbone of what they do, is keeping people accountable. I'm going back to Tampa right now. I started an organization down there in Tampa a few months ago. We fed 1,500 people last week. We're going to feed probably around 1,700 people this week. Tomorrow, I have meth addicts that have come off the streets. They literally come from outside the bridges, and we have a warehouse there where we have a food pantry. We gave 20-something women a shower last week. Well, we didn't, but they took a shower. Be clear about it. But, you know, the thing for me is that when someone sees something special in you and is able to hold you accountable to that, that's what community corrections means to me. Because they saw something bigger in me. You know, I've been on probation, man. I started smoking. I'm sorry, man. I'm not being disrespectful. I'm just street guys. You know, when I come off the streets, I mean, I didn't understand what accountability was. But once I learned it, it saved my life. It brought me back to life. I have 7 children, 2 grandkids, and I just don't know how I could have I couldn't have accomplished that and be a good father without community corrections. So that's my testimony. If y'all want to ask me any questions, you're welcome to it. But I'm going back to Tampa, and I'm blessing so many people, and not only there, but here. We've done Recovery Fest. We do so much. But it's all because of God, my family, and community corrections.
Thank you. Thank you for your testimony.
Yes, sir.
That is the last one on our list for this bill. Chairman Curcio, you have the first question.
Thank you, Mr. Chairman. Appreciate that, and I like the format. We got to hear sort of everybody at once, and I know I speak for the rest of the committee when I say this was some very powerful testimony, and appreciate you all being here. My question was actually for Ms. Schmid, if I could. And I just know, because obviously we've been working on this bill a lot, this and the next one, and we've been working a lot even today. You mentioned about the community corrections piece of this bill and about looking forward to working on it, but and I'm going a little off script here, so I can get in trouble later, I guess. But can you share with the committee or with anybody else, we've been working on a lot today, kind of what the intentions are as far as moving forward?
Yes, sir. Callan Schmid, Legislative Liaison for Governor Lee. So, I mean, I think we've all heard some of the impacts that these community corrections agencies can have, and that some of these agencies do really incredible, life-changing work that we've just heard. So we are working on an amendment with the community corrections agencies to take out sections 11 through, my memory, I think it says 44 of our bill, and rewrite, bring back, somebody mentioned it, the accountability language that we had in the bill last year that brings forth the data, looking at just making sure that we can evaluate the program, make sure that the money that's being put into the budget and being put out in these RFPs from TDOC, that we're making sure that we're getting a good return on investment, because there are some really incredible, great community corrections agencies that are doing great work, but there are also some who aren't as strong in certain areas, so we need to make sure that we're getting the resources to those to make sure that they can do good work in the community. And that'll be in the committee before full next week.
Thank you, Mr. Chairman, and thank you, Ms. Schmidt. And again, I may be in trouble after that. But so just to clarify, Section 11 through 31 of this bill eliminate community corrections. And what you've just talked about was that the amendment would remove Section 11 through 31 of this bill.
Yes, every part that addresses community corrections in this bill we're going to take out and hopefully have a nice clean amendment for you all in full that will put in some piece about accountability and making sure that we're working with the community corrections agencies and making sure that we're getting the data that we need.
Well, Mr. Chairman, thank you. Thank you for being such a great teaming partner on this. I know many members of the General Assembly are very glad to have their voices heard, their constituents' voices heard, and I think creating this kind of accountability matrix or a measurement matrix, because what we say down here all the time is, well, where's the data? Where's the data? Where's the data? Here we have an excellent opportunity working with a governor who has a passion for this issue to truly find that data so that we're not just taking a stab at something on a wing and a prayer. And so that, because I know that's not the style of this administration, that's certainly not the style of this General Assembly. And so I'm glad to know that once again Tennessee's leading, and thank you for being a great partner with us.
Thank you. Chairman Farmer is on my list. Do you have a question for?
I do.
Okay, yes.
Yeah, thank you, Mr. Chairman. And Ms. Smith, I just want to echo that in a way that I want to thank you and the administration, Governor Lee, for wanting to work with all the stakeholders here. I think that's very important. I think that's the way we get to good policy. And I'm going to make an ask, and I may go off script here, and I may get in trouble for this. But this is something we generally do coming out of subcommittee. So what I'm hearing is that there's going to be an amendment coming in, and that sections 11 through 44 are going to come out. If administration were to put those back in, would you tell us that, would you agree to come back to subcommittee so we could have this discussion here?
Yes, sir.
Okay, thank you.
Thank you. Representative Beck.
Thank you, Mr. Chairman, and thank you for all those who came to testify today. And it was really wonderful to hear what we already knew that you guys were doing. Ms. Smith, I've got just a couple of things real quick. The 8 years of you mentioned on this particular bill, reducing probation to a maximum of 8 years. We heard when the DAs testified that a lot of times the judge requires restitution, and in order to make that restitution affordable for the person, they have to stretch out the time. But, so what is the theory of not making that available to the judge's discretion under this bill?
Yes, sir. Thank you for that question. So right now, currently, the law is that you can have 10 years and you can stack those probation sentences as the DA's talked about. And what we're proposing is to bring it down to 8 years and not have the ability to stack it. The reason why, and restitution is incredibly important. We agree with the DAs. I think everybody on this committee agrees with the fact that we need to make the victim as whole as possible in the offense and make sure that they're taken care of. And I know that there's a bill that the chairman has that is later on the calendar that I guess y'all will get to next week. Sorry about that.
Maybe not.
So that will make the restitution process easier for the victim. The judge has the ability to convert restitution to a civil process. I think that's the right word. I'm not a lawyer currently. And so in Tennessee, we don't have debtors' prisons, and we don't need debtors' community supervision either. This is something that we can make sure that the victim is made whole, and that, but also make sure that that person is not, that offender is not getting tripped up on technical violations and having to go back into our jails and having to go back into our prisons. And instead, they are making sure that they're doing what they can. They're going out, earning a job to make sure that they're paying those fines and fees and restitution for those 8 years. Did I answer your question?
That does answer my question. I don't agree with it. And because when it goes, when it does go to civil, you know, they can, they can slow pay it, they can bankrupt it, they can make it go away. Whereas if it's part of their probation, then, you know, it makes it, I don't know if we're not being a little sliding the victim a little bit there, but I'll leave that up to greater minds. But speaking of money, I believe we took $9 million out of their budget for community corrections. If we do what you're say that we're going to do and restore community corrections wholly with just with some monitoring in the bill, I would expect that $9 million would come back from in the budget to the community corrections. Am I assuming correctly?
Well, unfortunately, I don't sign the paycheck on that specific issue, but I know that our team is talking about it and discussing it, and I just haven't heard back on the final decision. But I do know that that conversation is happening that way. So I'll follow up with you on that one.
Okay. And we will have that finalized by next week, I hope.
Yes, sir.
Very good. Thank you.
Thank you, Mr. Beck. Next on our list, Chairman Howe.
Thank you, Mr. Chairman, and thank you for being here. You do an excellent job, by the way, and appreciate your passion for reform, just like I think all of us do. We've had many discussions today out of committee about some reforms that are needed. And I commend the governor for recognizing that there is a lot of sympathy for our community corrections because of what they do. And I say that based on our last witness. I know the proposed bill that we haven't voted on yet would have saved about $9 million. But I don't know how you put a price on what's happened in this man's life. And many, many other people just like him all around Tennessee. And I've looked at the recidivism rates in the U.S., I think it's about 64%. In Tennessee, I think it's 47%. You compare that to what's happening in community corrections. I think one of our witnesses said his was 2%. Did I misunderstand you? Was it 2%? And I know Shelby County is about 30%. So my dilemma, while I support reform, and you and I have talked, you know that, my dilemma is how do we preserve the good while addressing the underperforming? And I think there's a way to do that. So I'm glad the governor is taking a step back to take a look at this. Thank you. Thank you, Mr. Chairman.
Thank you. Representative Hardaway.
Thank you, Mr. Chairman, and good afternoon, ma'am, or good evening. How do you define success for the programs?
The community corrections programs?
Yes, ma'am.
Well, I don't know if I'm smart enough to have a definition for success on this. I think I would like to give credit where credit is due and make sure that the folks at TDOC and working with the community corrections agencies, we're going to come to a good threshold to work on with them and make sure that that's defined in the amendment.
Okay. And the amendment would leave them alone completely, or does it collect data? Do they participate in a data exchange?
So it's, full disclosure, it's still being written right now. I have a draft in my email. But the intention is that the Community Corrections Grant Program will continue to operate as it has done since 1985 and have the good work that has, again, that we've talked about, and making sure that TDOC is having the opportunity to see that data and to evaluate that data and make sure that the taxpayer dollars that are going to those programs we're getting a good return on investment and good public safety outcomes.
Okay, and are the community corrections people at the table?
Yes, sir.
With TDOC?
Yes, sir.
And the folks in this room who testified are at the table?
A representative from the agency is. And I'd love to have conversations with these folks as well.
So you're inviting them to the table?
Absolutely.
Okay. And I say that with all seriousness because they're doing it right. They've obviously figured out some best practices, and what better place to learn than those who have gotten it right. So I appreciate that, and see some head nods out there, so I think your invitation is accepted. Looking forward to the follow-up. So the data that's going to be collected and analyzed and used to give them feedback and to, you're not going to take an active role in managing their operations, but merely in the exchange of data collection, giving them feedback.
The process will be as it has been. The process won't change from my understanding. We're still working on those details, but that's not the intention. The Community Corrections Grant Program, as it has operated since 1985, will continue to operate, and the partnership will be even stronger than it currently is between Community Corrections and TDOC to make sure that we've got good public safety outcomes.
All right. Are there any faith-based programs that y'all have, TDOC has relationships with?
You know, yes, sir.
Okay, excellent. I look forward to hearing a little bit more about that. Thank you, Mr. Chairman. Thank you, ma'am.
Thank you. Next on our list is Representative Griffey.
Thank you, Mr. Chairman. I want to thank Ms. Smith and all our guests here today, Mr. Bell, Mr. Walton, Ms. Holt, Ms. Clark. And I had a question for Mr. Morgan, and I don't know if we could have him come back up, and I got a question for him.
Mr. Morgan, you come up here to the podium here.
Mr. Chairman.
Yes, sir.
While he's waiting, may I also add to Ms. Schmidt that $9 million might double and allow these folks to do more work?
Thank you for that suggestion.
Mr.
Mr. Morgan, I'm sorry, Mr. Representative Griffey, go ahead.
Thank you very much, Mr. Chairman. Mr. Morgan, thank you again for being here today, and I congratulate you on the success that you've accomplished, and you had community corrections there backing you up. But I want to emphasize you're the one that did this, so we're all extremely proud of you. Here's my question, because this invariably rises up with folks that are trying to figure out, well, how do we address offenders that have drug and addiction issues, and we try to put them on probation. And we set up certain rules and restrictions saying, all right, don't use drugs, don't do this, don't get a job, do these things. There's a proposal, in the current law, if you are on probation and you slip and use drugs and you test hot, you got to go back in front of the judge. The judge could violate you and send you to TDOC for your full sentence, depending on the circumstances. There's been a proposal to change that says the first time the judge could only give someone 15 days, and the second time maybe 30 days, second time 90 days or something. The individuals who have these substance abuse problems, and a lot of them, I think, approach the situations, there's a risk reward. They want to reward their need for whatever drug it is. I was addicted to nicotine as a smoker many years ago, toughest thing to break, but I broke it. But you do reward, and you kind of tell yourself, well, if I just smoke one more, I'll be okay. And do you think it's beneficial if we ease up sort of the possible consequences if they violate a parole by going to a shorter period of time and the offender's going to know that on the front end? Or do you think it's better to keep it where the person you're trying to change their behavior doesn't know for certain what's going to happen? There's a bigger potential threat at the end. Am I expressing that? You see what I'm trying to ask you?
First of all, I applaud all of you who are in here because you guys make major decisions about all kinds of lives, and that's a huge responsibility. Fortunately, going back to why I'm here, this judicial system, speaking of community corrections, they're the reason why I'm here right now, outside of God. And I think that it's based on the heart of the individual, and that's why it takes such, if I may use this terminology, whether you know it or not, but discernment, and to be able to look at a person and see if they're serious or not. And that's why people like myself are so instrumental in helping. I've done major events not major, but whatever events with community corrections. Anytime they call me, I'm there because I've got to be instrumental. You can't just have people who have walked through life and never dealt with what I've dealt with and always make those decisions. It's called network. That's why we bring different people around and people who've been through different walks of life. So, I was interested in what this gentleman said earlier about, are they faith-based communities? Yes, there are. I'm all in. I do an event called Recovery Fest. But to go back to your question, that's where this organization, I believe, is instrumental because they do partner with people like me. They know what I'm doing, and when they need me, they call me, because you have to be, when you deal with an addict, you got to be really, really savvy. I've always said this, I'll say this, I'll leave it alone. You tell me when my time's up. But I've always said this, addicts are the most genius people in the world because they can wake up without 2 dimes to rub together and end up at the end of the day with a $10,000 high. And it takes a lot of insight. And that's why I'm so glad that you said that, sir, because it takes a lot of insight and discernment, because if you don't know these people, addicts are genius, man. They'll talk you out of the shirt off your back. You know what I'm saying? Before you know it, you done gave them enough money to go get another dope bag. So I hope I'm answering your question. It's just a lot on my heart, because when I come to these type of things, man, my whole life has been changed because of this. And so going back to what you're saying, shortening the penalization, I think that's just something that we have to lean on people who deal with them every day. Like, for example, Mr. Dillinger was my officer. He saw me every week, come to my house. I remember one day he showed up at my house, and I was weed eating. I was scared to death because I thought he was going to try to take me to jail. So, but, You know what I'm saying? Because addicts are already, they're prone and inclined to have people look down on them. So I understand your question. I think that's important, but it goes back to accountability.
Let me ask you this then, because addicts are geniuses at getting their high or their fix, if we have a system where the addict knows, look, the worst I'm looking at is 15 days, versus, well, if I violate and use dope or whatever, they could revoke my entire sentence. And so when an addict is thinking about that, sitting trying to decide, make the decision, am I going to stay clean or not?
They don't think about that.
They don't?
They don't think about that.
Okay.
They don't think about how long they're going to go if they violate. They don't think about that until they, excuse my crude expression, peeing in the cup.
Okay.
And that's where community correction comes in place, they're able to hold you accountable. If you pee in that cup and you violate, then you go, they need a good consequence. The thing that's so bad about society right now in the judicial system is we let people screw up, and then when they mess up, we put a little pillow under them to cushion the fall.
Thank you. Thank you.
Thank you, Representative Griffey. Chairman Farmer, you have a question for Mr. Morgan? You passed. Any other questions? Representative Hardaway?
Thank you, Mr. Chairman, and thank you, sir, for being here. Thank you for the work that you're doing.
Thank you.
The Recovery Fest that you've mentioned a couple of times, can you share some light on that? Shed some light, rather.
On the event?
Yes, sir.
What I did is, if I can just, I won't take you through all of it, but I grew up a pastor's kid. I was born on the road. My mom and dad were evangelists, and I was born on the road. That's all I knew was ministry. And because I was an addict and the child of pastors, I had so much condemnation and shame upon my life. And so something hit me and said, you know what? Let me throw a celebration for all the people who are at least trying. You know what I'm saying? I mean, at least you're trying. Because for an addict, unless you're an addict, you don't understand this. If you're an addict, every day you wake up, your mind is thinking about how can I get the next high? And that's what causes crime. You can always trace it back to drugs. Recovery Fest was an event that I put together because I said, you know what? I'm going to celebrate the people who are at least trying, because there's a bunch of deadbeat fathers out there. They don't pay child support. They don't do anything. And my job is to mentor them and shape them and get them back to a place where, first of all, they feel responsible for what they've done. So that's what Recovery Fest is about. Well, we do like a three-day event, and people from everywhere, New York, New Jersey, Florida, they come from everywhere. And what we do is we celebrate them and encourage them to keep trying. My dad used to tell me this. You may laugh at me, but my dad used to tell me and my brother, he said, forget being a Christian. Can you just be a good citizen? Right? You know what I'm saying? And there's a lot of truth in that. You know what I'm saying? And some people are so focused on being a Christian, they ain't even got to be a citizen yet. And so that's what I strive to teach these people because of what community corrections taught me. I'm able now to have a voice. You can YouTube it and you won't. Just look up Wes Morgan, 2 S's, no T. I have massive influence because I'm a hero. I'm just saying that. People in life look for heroes. If you're going through something, let's say you got breast cancer, they're looking for somebody who's survived breast cancer. They're looking for heroes. If you're trying to get over an addiction, you're looking for a hero. And I'm that hero, and I'm that Huckleberry, because I trumped it, and I'm still trumping it every day. So that's what Recovery Fest is about. We kick off with a big comedy show, because a lot of the thing is there's so many families that are affected by this. they're so broken and so hurt. So I throw a party the first night and just I bring in comedians and they do comedy show just to lighten the hearts of families that have lost members of their family, their loved ones, or who are dealing with people who are incarcerated. And so I do a comedy show. Then the next day, Judge Brown from Gallatin, he came a couple years ago and he did a segment on Saturday where he just shared about looking at me in the face every few months. And there was all these people here and all these families here. And so it's an encouragement to them because they see if God and community corrections can do it for me, why can't he do it for somebody else? And so that's really what Recovery Fest is about. It's just a big party and a lot of information and just kind of sometimes just take the load off people. People, if you've ever had a family member that you love that's been addicted to drugs and alcohol and been in and out of jail, it's hurt. So it's not just dealing with recovery, but it's dealing with prevention. You know, one of the things that hit me when I did Recovery Fest is that I wanted to tie that together because all these people who have come out of this lifestyle, they need to pour into the kids before they get into that lifestyle. Mm-hmm. And so that's what Recovery Fest is about.
Right. And this is probably my last question. When you're looking at the programs that are available from the various community corrections agencies now, where can we improve? What needs to be different to do it even better than it is now?
I think, and I've spoken to Mr. Dillinger and Ms. Jennifer through the years about it, and I think this is something they just not been in a position to do it evidently, but they want to do it. I think the best thing to do is if people come into community corrections and I'm already in that region, then to connect them with me because I can fix them. It takes one to know one. And I think that would be a huge, like if say we said, if you come into community corrections, not only do you have to check in and do a drug test, but you also have to go to Recovery Fest or go and get some real therapy from someone who not just head knowledge, but understands the game and knows how it works. I got a guy right now, he's been clean from meth for 3 years, and he's living on my property. I moved him in. He's my handyman. He told me the other day, he said, man, you changed my life. And that's what we have to do. It's going to be challenging to change these people's lives when they're not used to the structure that you guys are used to, if that makes sense. They got to have somebody who understands the routine of a drug addict's life to help them navigate out of it. So in order to change it and make it better, I mean, I would suggest, with whatever regions you're working with, I would love for them to connect with my foundation and let me help these people because I'm hands-on. All
right, I thank you once again for what you've done, what you do, and pray blessings on you as you go forward.
I appreciate that. I receive it.
Thank you, Mr. Chairman.
Thank you. Representative Griffey, you have a question for Mr. Morgan.
Just briefly, thank you, Mr. Morgan, again. You indicated you had a career, as an offender. Let me ask you, were you ever on state probation?
I think so. I've been on probation since I was about 13 years old.
Do you have anything you'd want to share with this committee when you compared your experiences as an offender under state probation supervision based on your experience being under supervision with the community corrections program?
You concerning just a comment about?
If there's anything to your mind, if you felt one was better, one provided you with better assistance or outcome to turn your life around and actually get you not to offend again and stop using drugs, was there any distinguishing difference in the way you were supervised by state probation officers versus community correction programs?
I'll say this, sir. I started going to juvenile detention when I was probably 12, 13 years old. and I was such an offender that I had to spend weekends, because juvenile detention, they won't keep them over, 72 hours or something like that. But I would get out of school on Friday, and my mom and dad would drop me off at juvenile detention and pick me up on Sunday evening. I went through juvenile detention through my whole teenage life, and then started going. I was tried as an adult, I think it was. It's been so much I can't even keep up with. But I was tried. I was convicted. Well, not convicted, but tried for armed robbery. I mean, the list is endless. I went through all of those things. I can't tell you how many treatment centers I've been to. But what I will say, sir, and the reason why I'm here today to testify and vouch for this community corrections organization is because they were the ones. I've never been back to jail since I went through that system. I've never had any more arrests since that system. And I've been through a lot of systems, a lot. More rehab centers than I even know of, more jails than I know of. I can't even remember how many times I was, had to go to jail and sit in jail. But I have not been back since community corrections. And that's about the best I can say it. Yes, sir.
All right, thank you very much. Representative Beck, you have a question?
For a previous witness,
Okay.
Mr. Chairman.
Who would that be?
Ms. Smith? Hi, Ms. Smith. You've already identified yourself. My question, I guess, to you is I've been sitting here thinking about and conversing about the issues that the DA's office brought up about probation and some other things. And you're going to be drafting a amendment. Can you, when you're drafting the amendment, can you talk to and try to work with the DAs on their particular issues going forward and see if we can't massage those?
Yes, sir. Well, I'm glad I brought my notes up here with me this time as well. Some of the concerns of the DAs, we've worked with them. I really want to thank Zoe Sams, Guy Jones. They've answered every phone call that I have harassed them over. And so one of their concerns that they brought up specifically today, and one that I should have mentioned earlier, is the restitution. And, there are some situations where a person has the ability to pay and isn't. And in that case, in the current bill, or the current amendment that's been adopted by this committee, we list out 3 specific reasons why the judge can extend probation for 1 year at a time. And one of those reasons is the ability to pay restitution and the unwillingness to do it. So the judge could extend it a year at a time. The other reasons are contact with a victim or a victim's family, and then failure to comply with court-ordered treatment. And so that gets the person in front of the judge who is not carrying out what they're supposed to be doing. It gets them in front of them every year until they do so. And it allows extension of probation.
That helps a lot because it appeared to me that the 8 years was a hard stop, where there are some provisions that they can continue the probation. Thank you very much. If y'all would look at that while you're writing the amendment, would be greatly appreciated.
Yes, sir.
Thank you.
Thank you. And I have a question. For you. Provided that this bill leaves this committee and is going into the full committee, in regards to community corrections, is it your intent with this next amendment that it is not going to eliminate community corrections in this state?
Absolutely. It is our intent that it will not eliminate community corrections. It will continue the program as it is currently, and it will establish a stronger partnership between TDOC and community corrections to be able to share data.
Thank you very much. Chairman Curcio, you have a statement you'd like to make?
Thank you, Mr. Chairman. I will reserve until we go back into session on the bill. Thank you.
Okay. Without objection, we will, Representative Hardaway?
Thank you, Mr. Chairman. And that was a wonderful commitment you made. Does that $9 million come with that commitment? I don't see how you go back to status quo without giving them their money back.
I'm
Tito.
so low on the totem pole, sir, that I don't make the decisions on the budget. So I'm going to have to check with somebody who is higher on the totem pole on that one.
Okay, and tell them twice as much money is quite likely to yield twice as much success. But I want to ask you whether the governor is looking at a comprehensive plan. A lot of what I heard Mr. Morgan say was about accountability. And I thought about my own childhood, which seemed to go until I was 30, about being accountable, being held accountable. And that trait and the character development, the maturity that comes from being held accountable. And he referenced that he'd been in the system since he was 13. So how are we dealing with this if we're serious about looking at prevention and intervention before we consider incarceration? Isn't a great deal of that back in the juvenile court system?
Sir, I'm so excited you asked about that. If you listen to the governor's State of the State, there is a whole initiative that's being rolled out that will address some of what you're talking about. I'd love to set up an appointment to talk to you about what's in that initiative.
I'd love that too, but can you give us a hint about it?
I don't know if I'm authorized to.
Well,
so-
Representative, with all due respect, we're on, that is might ought to make an appointment for that so we can stay on this bill right here. So.
All right. Thank you, Mr. Chairman. If you could make sure that you get that information back to the chairman,
Yes,
so he can share it with the committee, because it hit me as Mr. Morgan was testifying that we're only looking at we're downstream. Okay, we're downstream, so we've got to be able to get back to that juvenile portion, or a lot of this is wasted. We could have done something early on, and we're not going to get the efficiency of the dollar in dealing with it now that the problems are maturing, as opposed to the man or the woman. So, and thank you for your work, ma'am.
All right.
Thank you, Mr. Chairman.
Yes, sir. Thank you. Thank you. Without objection, we will go back into session. We are back in session. We are back now on House Bill 784 as amended. Do we have any questions for our sponsor?
Thank you, Mr. Chairman. I'll just say finally, we've heard a lot of discussion today about, and I'm clearly Community Corrections is doing some very good work. We know that. Obviously, a big portion of this bill, as amended, deals with community corrections. We've heard about an upcoming amendment. I just want to point out, and I didn't want to say this while we were at a session because I'm not trying to spur a longer debate. To me, this is actually why we need to move forward with what the governor's office is proposing. We've heard about these very low recidivism rates. 2% was bandied about for one particular program earlier. As I pulled the report down, downloaded it from TDOC's information, that same program is reflecting a 64% recidivism rate. I'm not saying TDOC's right, and I'm not saying you're wrong. I'm saying we're clearly not talking to each other. So I look forward to moving forward so that we can get the right data and the real facts, because it's apparent there are obviously great results coming out of the program. I'm sure, like anything else, there have also been some failures. That's a natural part of life. But clearly, that's what underpinned for me that we need to be talking more and not just immediately throw the baby out with the bathwater. So with that, I renew my motion.
Thank you very much, Representative Griffey.
Thank you very much, Mr. Chairman and sponsor for the legislation. I just respectfully cannot support the legislation. I think for these particular reasons, look, we have the subject matter experts, the DAs, and the people who supervise offenders here, and we even have an offender that is telling us the problem is when somebody violates, we're offering them a pillow. And the DAs are telling us that this proposal by the governor, with all due respect, we're going to lessen the potential punishment for people that violate the conditions of probation. It will save some money, sure, but from my experience prosecuting cases and a defense attorney, criminal defense attorney, we have a vast number of people that have mental health issues that need to be addressed, and they end up in our jails. And drugs are the driving force of most of our criminal conduct and people in our jails. So I can't support this legislation based upon listening to the subject matter experts. I don't think this legislation is ready to be passed, and I would advocate that we not pass it. I think it is soft on crime, I'm sorry to say. Thank you.
Thank you, Leader Lamberth.
Move previous question.
All right, previous question has been called. Any objections? Seeing none, we're now voting on sending House Bill 784 as amended on the full criminal. Those in favor say aye. Aye. Those opposed, no. No. The ayes prevail. It moves on to full criminal. If you wish to be recorded as a no, please see the clerk.
Thank you, Mr. Chairman. Thank you, committee.
Thank you. Next item on the calendar, House Bill, we're at number 34, House Bill 785. We have a motion and a second. There are two amendments that are traveling with this. Amendment number 005041.
Yes, sir. I move amendment coded 5041.
All right. Motion and a second on the amendment.
Thank you, Mr. Chairman. Thank you, committee. What this amendment does is it adds offenses for which seriousness of the offense can still be considered by the Board of Parole.
All right. Thank you. You've heard the explanation. Any questions for the sponsor? Yes, sir. Leader Lamberth.
Mr. Chairman, thank you for carrying this, and thank you for the amendment. I think this is definitely a step in the right direction on making sure the parole board can still take into account seriousness of the offense when dealing with these horrendous crimes that have victims that have had their lives changed forever by this. So thank you, and thank you for the governor for working on this to ensure that it's still an option for the parole board to look at.
Representative Griffey.
Thank you. Question, are we going to have anybody from the DA's conference or anybody else to speak regarding this bill before we vote on it? Do you know?
We are taking up the amendments right now. Once we get the amendments on the bill, we'll go out of session and then hear from those.
Thank you.
Yes, sir. Any other questions? Seeing none, any objection to the question? All right, we're voting on adding amendment number 005041 on the House Bill 785. All those in favor say aye.
Aye.
Those opposed, no. The ayes prevail. We also have a second amendment, code 005301. Have a motion and a second. That is by Representative Russell.
Thank you, Chairman. What Amendment 5301 does is states that on the fourth revocation, the remainder of the offender's sentence will be reinstated. It is my intent to allow judicial discretion in a future amendment in the full committee. Thank you, Mr. Chairman.
All right, thank you. You've heard the explanation. Any questions for the sponsor of that amendment?
Question on the amendment?
Question has been called. Without objection, we're now voting on attaching amendment number 005301 on the House Bill 785. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. We will now roll those two amendments into one and attach them onto the bill. And now we're on House Bill 785 as amended. Chairman Curcio.
Thank you, Mr. Chairman. Thank you, committee. This board is commonly known as the Reentry Success Act of 2021. Again, as we talked about before, the previous legislation dealt with alternatives to incarceration. This deals with what happens on the back end once you've completed that sentence and you're reintegrating into society. But it does a number of things. Requires the Board of Parole to establish a digital function so that the victim may record a video witness impact statement by video, which was a bill that I think came before us last year that didn't make it to the finish line. I think the administration liked it enough to want to incorporate it here. It also removes the application fees associated with the restrictor's driver's license issued after failure to comply with an installment plan for payment of criminal offenses, litigation taxes, court costs, and fines. Makes changes to periods between certain Board of Parole hearings requiring conditions or limitations prior to release and determination of revocation of parole. It creates a presumption that an eligible inmate must be released on parole except for good cause shown upon the inmate reaching the inmate's release eligibility date and any subsequent parole hearing. Establishes mandatory reentry supervision. This is something we heard in the task force. Again, both of these bills brought about not out of thin air, but from subject matter experts pulled together from across the state, DAs, victims advocacy groups, lay people in the community, folks from nonprofits, and folks from our own Department of Corrections and so forth. And what we heard over and over again from victims, which I think was a surprise to a lot of us, was, we would be okay with someone coming out a little bit early if it meant that they had mandatory supervision so that we knew that they were on their feet and doing well and more importantly, not creating new victims or re-victimizing their old victims. And so that was something that I was actually surprised to hear from the folks who representing the victims community on this task force. I'll stop there and take any questions from the committee, but thank you.
Any members have questions for the sponsor or before we go out of session? Representative Hardaway.
Thank you, Mr. Chairman. To the sponsor, the 1 year of mandatory reentry supervision, is that evidence-based or is that a budget-based? Why do we choose 1 year?
Evidence-based.
No. Thank you.
Representative Beck.
Thank you, Mr. Chairman. To the sponsor, we heard you were speaking of parole earlier. We heard a lot of testimony where someone was granted parole with the requirement of taking some classes while they were still in, and then those classes didn't make or weren't offered, and people were, even though they'd been granted parole, were staying in prison for months and years after the granting of parole. Does this bill do anything to alleviate that concern or that problem?
Yes, sir, it does. And I'm trying to find the applicable section for you there. But it does deal with that generally and talks about the types of programming that's available, and if there is no program available, and not holding that offender accountable for the absence of a program. I'm getting some hand signs, but I'm not sure I know what they mean. Section 10. Okay, sorry. Thank you. Yes, in Section 10, thank you. Sets forth that the Board of Parole cannot order programming as a pre-release condition that has not been recommended by the department. So the idea is the department wouldn't be recommending something that was not available. Sorry for the long way around there.
Representative Beck.
Yeah, that's what I was about to say. Recommending something that's not available, but if it is available, but it doesn't get offered or coordinated, they still sit in jail instead of being able to take that requirement outside the facility. How is that relieved? The wording there that you just read didn't relieve my concern.
Can you restate your concern?
My concern is that XYZP is made a requirement of parole. X and Y are offered, but they're offered at another facility. They're not. Their classes don't make, and the person sits in the facility waiting for that class. What you just read said that they're not responsible for classes that aren't quote unquote available, but that means that they are not offered. But what if they're offered and they're just not available? Does that make sense?
I'm sorry, it does not, but I know we're going to hear some testimony from the administration as well if you want to ask that question again. But again, it's my understanding that the Board of Parole cannot order programming as a pre-release condition that has not been recommended by the department. So again, in this bill, we're really relying upon those strong R, the risk needs assessment that we're now giving to every offender when they come in, and then tailoring that programming to each offender. And so the idea is that we're trying to make sure that the prescription lines up with what's available.
If say you're given a anger management requirement, and that anger management doesn't is not offered in your facility, and is there a time limit if they don't have the ability to take that anger management within 6 months? Are they going to go ahead and be released and let that anger management be taken on the outside? Or are they going to keep them till that they can finally make that class of anger management? That's my question.
Thank you, sir. I apologize for it. I guess it's
the
late hour. Yes, so this bill specifically sets up that if a recommended program is available in the community, that they would be released to the community to be able to complete that program.
Great. Thank you, sponsor.
Yes, sir. Sorry about that. Thank you.
Any other questions for the sponsor? Seeing none, without objection, we'll go out of session and hear from our guest. We have a representative from the District Attorney's Conference. If you'd like to come up, you can stand or sit. It's your choice. Without objection, we're out of session.
Thank you,
Sorry
Chairman.
about that.
Amy Wyrick, District Attorney from Shelby County and President of the Tennessee DA's Conference. And again, as we spoke about earlier this morning on 784, the DAs are not here either in support of or in opposition to this legislation, merely to point out some issues that we have all discussed openly. And to Ms. Schmidt's point, many of us have been involved in this from the beginning. Same thing with 785 as with 784, concerns about victims, concerns about moving farther away from truth in sentencing, and concerns about the fact that reform has to mean more than just merely release. And as to 785, we've already touched on some of those issues, and by the amendments, those have been taken off of our list of worries, but the wholesale early release of offenders, while we may understand the reasoning behind that, causes us concern as prosecutors for notification to victims and who is going to be responsible for notifying the victims of all of those crimes that this offender is now going to be released 1 year earlier than we had originally discussed. So that's one issue that we have, as well as the concern, and Ms. Schmidt said something that I think we all agree with, that probation should not be one size fits all. However, written into 785 is this idea that Representative Griffey has already spoken to of a remedy that is one size fits all, a punishment that is one size fits all. And if offenders know that what they are balancing is 15 days in jail after I've already done 8 years, or 30 days in jail after I've already done 8 years, those issues cause us concern, not to mention the fact that an offender could be on probation in the state of Tennessee for rape. Let me say that again. Our laws do allow for rapists to be on probation, and that rapist could commit an offensive touching against the same victim. That's a B misdemeanor, and all the judge could do is sentence that offender to imprisonment for 15 days. That's a tough conversation to have with the victim. What we saw on the Capitol this summer. Those offenders, if they had been convicted of arson and came back and committed a disorderly conduct, the most the judge could do is 15 days as this bill is written. And those, again, those issues cause us as prosecutors concern because you're tying the hands of the judge. You're tying the hands of the judicial expert and the prosecutor who know these cases and know the individuality of the offenders in front of them and know the obstacles, know the issues of the West Morgans in their jurisdictions and how best to address those. So that's one of our concerns. And this, again, just moving us farther away from this idea of truth in sentencing and really being able to tell offenders that when you are victimized, you are going to do a prison term, and it is going to be this long. and that what happened to you as a victim means something to us as a public safety issue and as a criminal justice system. And with that, I will answer any questions at this time or be available for questions later.
Thank you. We're going to go ahead and hear from our next guest, and we'll copy the same model that we used on the last bill.
Thank you.
Ms. Schmidt, if you would, you come up, you'll have 4 minutes. And then we will be able to go back to each of these ladies for questions.
Hello again, Chairman. My name is Callan
Greetings.
Schmid, and I'm a legislative liaison for Governor Lee. I'm here to talk about the Reentry Success Act of 2021. You've heard the governor speak for many years about the importance of transparency and accountability and improving public safety in our state. Both of these factors have shaped the way we've approached this legislation. We know that justice applies to both the defendant and their victim, and that part of successful reentry is making a victim whole as the best we can. Through our Victims Roundtables, we discuss many victim priorities and have incorporated responses to many in this piece of legislation. We address trauma by creating a long overdue process allowing victims and other parties to submit and preserve video testimony for the Board of Parole. We address full and timely payment of restitution in a few ways. We know that to have the ability to pay, you must have a job and a way to get there. We remove the application fee for a restricted driver's license for those who are compliant with a payment plan and limit employer liability for those who make good faith hires of those with certain criminal records. We also clean up the process for occupational license review, prioritizing safety-driven decision-making. Now let's talk about parole. We want to preface these sections with a clear statement that we believe parole to be a privilege earned by an inmate and not a right. We also think it is important that individuals aren't re-adjudicated by the board and that their behavior and demonstrated rehabilitation should be the focus of a parole granting decision. We also know we need tools to put pressure on the inmate to complete the programming they need and to demonstrate good behavior. As such, we've returned the window the board can punt parole decision-making from 10 years back down to 6. Section 10 prohibits the board from imposing pre-release conditions of parole if it is not indicated as needed for the inmate by TDOC's risk and needs assessment. If inmates who do not have a need for the program are taking up seats, then inmates who need the program may not have access. The bill makes it clear that behavior and rehabilitation, dynamic factors that require inmate participation, are the primary factors on which parole grant decisions should be made. Except for those who have committed an especially heinous crime, outlined by a list, seriousness of the offense is no longer able to be the sole basis for denial of parole. The bill creates a framework for mandatory reentry supervision, supporting the critical importance of parole in providing high-quality reentry supports needed to reduce recidivism. Expiring or flattening a sentence and walking out of a prison with no support or supervision is not in anyone's best interest. The framework outlines who's transferred to community-based supervision after reaching their release eligibility date, including when an individual has less than 1 year to serve or isn't parole eligible at all. Now, I'll talk about what we do once an individual is released on parole. The law is clear on responding to new criminal acts, but has caused confusion on how to address technical violations. The bill creates a framework for addressing technical violations of parole, those non-criminal conditions of parole overseen by TDOC. Under the proposed framework, a suggestion from members of the task force, technical violations are punishable by graduated days of incarceration, which we developed with sheriffs, chiefs, and DAs last year. Judges are already using what they call shock incarceration, so this bill standardizes the practice across jurisdictions. These changes do not impact a judge's ability to revoke an individual for commission of a new crime. Finally, we know that 60% of our felony releases each year come from jails, and that these individuals need high-quality, evidence-based programming as much as anyone. Section 18 establishes a new tiered reimbursement system for jails across this state to support more programming. We've heard time and time again that jails are stretched to the end of their means and unable, for many reasons, to provide evidence-based programming in the same way as our prisons. This program will create 2 tiers of accreditation, each with their own increased reimbursement rate. For years, we've seen the recidivism rate for local jails be higher than our prisons, and we are excited to work with jails to improve these outcomes. Thank you, and I'll take your questions.
Thank you, ma'am. Do we have any questions for our guest? Representative Hardaway.
Thank you, Mr. Chairman. Thank you, Mr. Smith, for coming back for more questions. General Wyrick cited an example of how an individual, she used the example of a rapist, could reoffend against the same victim and have a ridiculous sentence. Can you comment on that?
We do not address sentencing in this bill, but talking about, are you referring to the technical violations piece in the 15? Okay. So that would be a Class B misdemeanor. I'm not a lawyer, so I'm just going to go with a Class.
Not the technical violation. Well, I'll tell you what, I'll save that for General Wyrick.
Okay.
Thank you, ma'am.
Thanks.
Any other questions?
Just one more, Mr.
Okay.
Chairman. The fiscal note that comes back after the amendment is prepared will reflect that $9 million.
On the other bill?
Thank you, ma'am.
I think we're on the Reentry Success Act.
Right. Representative Beck.
Talk to me about the limitation of liability on employers. This prevents any action. Say, for example, I owned a heating and air company, and I send someone with a criminal record in to fix your heating and air, and they steal or worse, do something even unmentionable. This is going to give no recourse by the homeowner on the employer for negligent hiring. Am I reading that correctly?
So I'm going to have to read a little bit directly from the bill instead of editorialize, which I always like to editorialize. But subsections A and B of the section 17 do not apply when the employer or contracting party knew or reasonably should have known the employee's or independent contractor's prior conviction, the employee or independent contractor was previously convicted of an offense that was committed while performing duties substantially similar to those reasonably expected to be performed in the employment or under the contract. So there are some exceptions that would apply in this situation.
Okay, so run that one by me again. What are the exceptions?
So it's under C1. The employer or contracting party knew or reasonably should have known the employee's independent contractor's prior conviction. The employee or independent contractor was previously convicted of an offense that is substantially similar. I'll condense there. Or a violent offense was also excluded in that as well.
So the employer is only shielded from liability if they don't know of the offense? Is that what you're saying? I'm sorry, I'm having a hard time putting this together.
Yes, sir. So a cause of action can't be brought against the employer for negligent hiring, training, retention, or supervision of an employee based solely on the fact that the employee contractor has been previously convicted of a criminal offense. That's where we start out with.
Right.
Next, we go to, in a cause of action, the evidence that the person has a criminal record is not admissible, except for if the employer hired somebody and knew, like, trying to think of an example. We worked with Chairman Carter on this language last year, so he was really helpful in shaping this with us because he's got some businesses in his district that worked on that, and so I also want to give credit to Chairman Carter on this. But the employer should have known that the offense was similar to what they were putting that person in this situation of. So
if they robbed houses and then I
Yes.
sent them on a service call
Yes.
as ABC HVAC,
Yes.
then I should know that they rob houses and not to send them into people's houses.
Yes, that's a much more eloquent way to say that than I was, but yes, sir.
Okay. And what's the purpose of this limited liability?
So we, in the General Assembly, that's why I say we, have put in lots and lots of funding into correctional ed and getting TCATs set up inside of our prisons and making sure that when people are serving time that they come out, and you can see this throughout our bills in multiple places, that they come out and they can get a job. And so we want to make sure that we are also helping employers who want to hire those offenders and make sure that they feel that they can hire them and that there's an incentive isn't the right word to use, but that they're going to be protected in that protected in hiring people and doing good work and making sure that these people have jobs and can get back to being productive members of society.
Second question, or second subject, taking parole from 10 to 6 years. Don't you think that there's people who need parole for 10 years and we're limiting the ability of the, again, like probation, we're limiting the ability of the judge to make that independent judiciary finding?
Thank you for asking that question. So this, the parole hearing, so initially this person would be denied for parole. Currently they can be set out for 10 years. The average hearing and kind of the more extreme is 4 years, so we're still above that average. I wish I had more data for you, but just in my kind of having worked on these bills for 2 years, I've only seen less than 5 instances, really only 1 instance where somebody's been set out for 10 years, and that just recently happened. So this brings it back down to the pre-2016, I believe this was changed, level where they would be more frequently, brought in front of the Board of Parole at an appropriate time to make sure that if they need to get programming and complete their risk and needs assessment programming that's done by TDOC, that they're doing that to make sure that they're ready for the Board of Parole consideration.
Thank you.
All right, thank you. Any other questions for our guest? Seeing none, without objection, we will go back in session. We're now back in session.
Mr. Chairman?
Yes, sir, Mr. Hardaway.
I was under the impression that General Wyrick would be able to respond to that question about the, expound on the issue that she cited, the example of the rapist reoffending with the same victim.
Representative, I just asked if there were any other questions for our guest, and no one raised their hand, so after I went back in session, you did. I didn't see you. I'm sorry.
Mr. Chairman?
All right, we're back in. We are in session now. As the posture we're in, we're on House Bill 785 as amended. Leader Lamberth.
Mr. Chairman, I know it's late, but I know we're kind of gotten into a lot of testimony today, but obviously any questions that the members still have, I'm sure the sponsor of the legislation is happy to answer. I mean, it's just, I've asked a few even offline based on some of the questions. So, I mean, it's not like there can't be additional questions. Nobody's called question yet. I hope we may be getting to that rapidly. But at the same time, I don't think, Chairman, that you cut off questions. It's just the testimony. So just wanted to kind of mention that as a parliamentary point.
Thank you for that. I have Representative Griffey on the list here.
Thank you, Mr. Chairman, and
Got you.
regrettably, I can't support this legislation. I don't think it's good public policy. I think it will create more danger and more crime in Tennessee. I think it is probably offensive to so many victims of crimes in Tennessee that someone's supposed to be serving a sentence, they get an automatic year off their sentence. And I agree with my great friend and colleague from Sumner County. We probably need to rewrite Tennessee's criminal code so that there is truth in sentencing. And I would advocate that the federal system has a model where you do 85% of your sentence, no ifs, ands, or buts. And then after that, you're put on a supervision program where the probation supervision office works with you to make sure you're employed, not using drugs, paying restitution, and so forth. And I think I would like to look at the statistics for how the federal system works and what sort of recidivism they have versus state with our current program. But our current program, I don't think, is where we need to be to try to achieve the goals of getting people not to reoffend and getting them back to work. I'm going to say one other thing. If you're up for re-election in 2022 and you're going to have somebody that's running to the more conservative side of you, if you vote for this, I bet they'll use this against you as being soft on crime. I'm just calling it like I see it. Thank you.
Thank you for those comments. Representative Hardaway.
Thank you, Mr. Chairman. In lieu of being out of service and hearing from, and yes, that was intentional, and hearing from General Wyrick, I'm going to ask if Lita Lambert could address that example that she used for the rapist reoffending and getting a slap on the wrist, reoffending the same victim with a different offense and getting a slap on the wrist, taken away from the judicial discretion for a harsher response.
Leader Lambert.
Thank you, Mr. Chairman. I don't mind answering that question. I think what General was referencing is that anything that's below an A misdemeanor. So it would have to be a very minor crime, a disorderly conduct, something of that nature. If it was something that was a new stalking, another charge of rape, any type of felony, I mean, all of those would not be excluded from this. I mean, those would carry not only the additional penalties with the new crime, which would hopefully a judge would run that consecutive to whatever they were on. In fact, I think they have to. But it also would trigger an actual violation and potentially put into effect the sentence. So it would be, but if there was something that was a B or a C misdemeanor, so C misdemeanors, we're talking public intoxication, traffic offenses, that type of thing. B misdemeanors, we're talking about reckless driving, disorderly conduct, a low-level assault where there's no physical harm whatsoever. Those type of offenses would not trigger imposing the full sentence. They would trigger these less serious penalties. So less serious crime, less serious penalties, but if you hit an A misdemeanor or above, so new assault, new sexual offense, new rape, anything of that nature would definitely trigger an imposition of the sentence, at least my reading of this. And I will echo comments that were made earlier and by our witnesses. It is way past time to do a full sentence rewrite. I'm not going to belabor the point. I've said it 400 times in the last 9 years. I'm sick and tired of waiting. I mean, and by the way, that 400 is probably not an estimate. That's probably about right. Chairman Farmer and I came in together, and he's nodding vigorously down there. He's heard this over and over. Let's do it this year, next year. Let's get it done. Half of this bill isn't the best possible way that we can try to make our current broken sentencing system work. I mean, this is a great step forward to be tough on crime and to get, offenders back into line. That's the goal of probation or parole. We could lock them all up, just throw away the key. I'm fine with that too. But we're going to waste a lot of prison beds. And quite frankly, with folks that we could supervise through probation or parole and keep them in line without that prison bed. You put them in prison, they're guaranteed not to reoffend. But it is pretty difficult to do that with just every single offender. So this is the best possible option that we have to keep our community safe within what I consider a broken sentencing structure. But until we are all ready to really look at a sentence where if General Wyrick puts somebody in for 10 years or ask a judge to do so at 30%, they're going to be up for parole in a year and a half. We are lying to victims. We are lying to defendants. And I say we as the state of Tennessee. Nobody can tell you how long somebody's going to serve. That's wrong, but until we can get to that conversation, this is certainly a good step forward. Thank you, Chairman, and I hope that answers your question to my friend from Shelby County.
Representative Hardaway, does that answer your question?
Well, it answered a lot of questions, but it really didn't get to the example that she used where offensive touching, I believe a B misdemeanor, that the judge could only send the defendant back to prison for 15 days and he could already be on probation for rape. But, Mr. Chairman, I thank the leader, and I'll look forward to asking General Warwick that same question in full committee.
Very good. Thank you. Any other questions for our sponsor? Chairman Howe.
Thank you, Mr. Chairman. To the sponsor, as I stated earlier, I am very supportive of reform, but not at the expense of the victims. And so I have a question about the current bill before us to the sponsor. I believe under the current system, anytime someone comes up for parole, the victim is notified. How does this reform bill impact the victims? Will they still be notified?
Thank you, Mr. Chairman. And yes, sir. This bill doesn't change that at all. So, in fact, I think it's maybe a good opportunity to kind of brag on TDOC and the work that they've done. But they've got a completely separate system that manages that victim communication aspect. It's my understanding it's been revamped and will go live. The newest system will go live here just in a week to 10 days or so. And so not only does this bill not touch that, but just so you know for your own edification, that system has grown by leaps and bounds and has become very efficient.
Okay. Thank you, Mr. Chairman.
Yes, sir.
Thank you. Representative Hardaway has one more question.
Yes, sir. And I guess I can go to the sponsor on this. General Warwick expressed concern on behalf of the DAs for notifications to the victims. And are you saying that the TDOC system would be responsible for that, or is there additional dollars to help the DAs to handle those additional notifications?
Thank you, Mr. Chairman. So again, what I'm saying is that this bill does not change that system at all. It is separate and independent from this. And again, I take the opportunity to brag on it. What this bill does do for victim notification is it allows them to record a victim impact statement and submit it via video so that they don't even have to appear in person, which again was an advancement that this committee, or a predecessor to this committee, saw fit to move forward last year, but unfortunately did not become law. So this does not impact that communication in any way whatsoever. That system is alive and well and separate apart from this bill, but it would allow victims to record a video, which I think is another positive step in the right direction.
Okay, that didn't address my question, but I'll pose it again to General Warwick in full. She had stated that there was going to be just an avalanche of additional notifications that would be necessary, and that it would, she didn't say overwhelm, but that it would put additional burden on the DAs to handle that. And I was asking whether our fiscal note reflects the additional personnel or the additional equipment, whatever it is that the DAs are going to need to handle that component. Thank you, Mr. Chairman. Thank you, sponsor.
Thank you. Any other questions? Chair Lady Moody.
I guess to the sponsor, I know I've been told, and I'm sorry I can't give the specific place or what, but of a instance where victims showed up to the parole hearing and knew their time would be limited, but when they got there, they were told to pick one, and only one could speak. So if you get a bunch of recordings, is the same thing going to happen? Are they going to be able to hear all of them? So that's a question.
Thank you, Mr. Chairman, and thank you for your question. Not only will they be able to hear them all, but that recording will live on in perpetuity. So heaven forbid I record that and then I don't live to see the next hearing. That video, that victim impact statement lives on.
Thank you. Any other questions? Representative Griffey.
The sponsor, is it mandatory that they have to play those videos at every parole hearing? Is that mandatory? Thank you.
It's my understanding that if it's part of the file, then when they bring that case up, then those videos are there. And I know my jokes are getting better as the night goes on.
No, whether they're in the file or not is one thing. It's whether the parole board actually sits there as part of the hearing and goes through all of them so that everybody is aware of what that victim said in that recorded statement before a vote is taken on parole or something. That's my question.
I trust the good members of our parole board to make sure that they do their jobs thoroughly. We pay them enough.
Representative Beck.
Very quickly to the sponsor, does this bill affect expungements?
No, sir, this bill does not touch on expungements at all.
Very good, thank you.
Chairman Farmer. Question has been called. Any objection? Seeing none, we're now voting on sending House Bill 785 as amended on the full criminal. All those in favor say aye. Aye. Those opposed, no. The ayes prevail. Bill moves on to full criminal. Members, before we adjourn for the remainder of the evening, we do have many items still left in our calendar. Without objection, we are going to roll all those remaining bills onto next week's calendar. All right, members, we will entertain a moment to be adjourned, or motion to be adjourned. All right, we're now adjourned. Thank you.